Okay, in this video I'm going to talk about the differences between a will and a trust generally, and from these differences maybe you can figure out which one is right for you. So first I'm going to talk about the main similarities between a will and a trust. A will and a trust both say who's in charge when you die and who gets what when you die. That's the key similarities that both documents will control. Now the main difference is the arena in which the will or the trust will apply. The will apply if you're doing a probate court. In order for the will to work, it's going to probate. If it's a trust, the trust is all private. It's a private transaction without the involvement of the court or legal system. So let's talk about the differences between each and how it might apply to you. And there's three of them that I like to mention. Is first the cost, then privacy, and three, the difficulty in challenging it. So first, the cost. The cost of a will to set up now is much less than the cost of creating a trust now, because essentially what you're doing with a trust, and the reason why it's more expensive now is because you're dictating and how everything will go in terms of incapacity in your death, and the terms of the trust can continue on long, versus a will which can be just stated once and doesn't have any immediate effect. The will becomes effective in a probate court, so it could be just a cut and dry explanation, although a will can have a trust inside of it that makes the money pass on in longer periods of time. Number two is privacy. So the main difference again is the will must go to probate court. Trust is a private agreement between the family almost. The will is actually filed in the courthouse when you pass away. So anyone can see your will and what you left whomever. The trust does not have to be filed. The contents doesn't have to be shared and completely shared with everybody, or the bank. You can give specific pages, certain pages that they ask for. You don't have to give the whole thing. It's private documents. A trust, nosy neighbors can't see what you have in there. If you're famous or have some level of notoriety, snoopy people can't see into your personal financial affairs. Okay, so number three is the difficulty in challenging an estate. But in some states, you can actually put provisions in wills and trusts about penalizing anyone who challenges it. State of Florida, we do this. The courts do not uphold those provisions, but in a will in the state of Florida, is filed so anyone can see it. So it's a lot easier to challenge it. You can actually file something in probate court to let you know if a will gets probated, and so you know when to draw your sword. Versus a trust, which in the trust law in Florida says something to the effect that if you are not a beneficiary in this trust, then you're not even entitled to see it. So a lot of times, if you leave somebody out of your trust, and your kids, they're going to administer the trust, and then there's like a black sheep child that you left out, the black sheep child can't really see it unless he goes to court, and it's not gonna work out well for him. So those are the three biggest differences, and to help guide your decision of whether or not to do a will-based plan versus a trust-based plan. So good luck in your estate planning, and I hope you enjoyed this video.